Hey folks, Elie Honig here. This week we're diving into the controversial Subway chokehold case here in New York City, in which former Marine Daniel Penny was accused of killing Jordan Neely, a homeless man, by putting him in a chokehold. On Monday, the jury found Penny not guilty of negligent homicide after the dismissal of a more serious charge of manslaughter. The jury could not come to a unanimous verdict on that. Joining me today is Rikki Klieman. She is a former prosecutor and a criminal defense attorney, and she's also a legal analyst for CBS News. Well, we are so privileged today to be joined by Rikki Klieman. You probably know Rikki. She is a longtime criminal defense attorney and a CBS News legal analyst. She has seen many of the biggest cases, analyzed them over the past several decades. And what a thrill to have you here, Rikki. Thanks for joining.
It's my pleasure to be with you, Elie.
Good. Well, we got a good one today. We are going to be talking about the case that somehow has become only the second most attention-grabbing case in New York City this week, which is the verdict on the Daniel Penny case. Of course, the shooting of the CEO of Brian Thompson has sort of shockingly dominated headlines. But in some ways, I think this case, I don't think there's much legal around, right, the shooting of the CEO. Like, the guy's going to be charged with murder. He should be convicted. There's not. But this case, the Penny case, the Subway case, I think presents a lot of really interesting and important legal subtleties and ambiguities. So, Rikki, if you would, can you just remind our listeners of the basic facts of the case that led to this charge?
What we have is, in New York, a typical day, or so it started, in a subway car. And the subway car was crowded. At some point, there is a gentleman by the name of Daniel Penny who gets his place, enters the subway car. He is a Marine in his former Marine. I guess you can never be a former Marine. You are once and always a Marine. He is someone who was trained in the Marine Corps, got up to the level of sergeant. And here he was just minding his own business, getting on the subway car to be able to go to wherever he intended to finish. Then in the middle of this journey, a gentleman gets on the subway car and he appears to the passengers in that car to be, kindly, I will say, a bit unglued. He is untethered. He is screaming, as has been described. He is saying that he would be willing to die. He becomes, in the eyes of the subway passengers, a very threatening force. Now, it does not matter that ultimately he did not have a weapon on him. What matters is, how did those people feel when they were, as many of us have been, trapped in a subway car with someone who is emotionally disturbed? At some point, his threats become so loud and so imminent that in the mind of someone who was trained in the Marine Corps, like young Daniel Penny, he decides that he should come to the aid of his fellow passengers as well as himself. But you have women and children on the subway car. And what he does, according to what he believes is his training, is he comes at the person who eventually dies, Jordan Neely. He comes to Mr. Neely from behind and he puts him in a hold, which is called a chokehold of sorts, and he brings him down to the ground. He is then, Mr. Penny is supported by two other passengers who come to the aid of Mr. Penny in subduing Mr. Neely. There is a factor that should be irrelevant, but it was not irrelevant in how the case was charged and prosecuted, is that Daniel Penny is white and Jordan Neely is black. Daniel Penny has hold of Mr. Neely from behind on the ground of the subway car as it keeps chugging along to its next stop, supported by the other two men. And at some point, it appears that Jordan Neely has stopped resisting. and that it appears that he may not be breathing. So when they get to the subway stop, by this time you have people in the subway car who are filming, you have people who are looking and calling 911, and the police also arrive. So Daniel Penny waits for the police, and he waits to see what he should do, what he should say. He needs to be able to talk to the police and explain from his point of view that he was acting, in essence, as a good Samaritan. He was trying to save the people in that subway car.
Good. You've painted a very vivid picture of what went down in that day, and I think accurate as well. So let's first take on, I'm going to ask you a sort of objective question and a subjective question, and you can handle them however you want. Well, let's start with the objective one. Explain to us how the DA, and I should say everyone who watches this podcast, listens to this podcast, reads my stuff, knows Alvin Bragg is a former colleague of mine at the SDNY, a friend of mine. Although, as anyone who has watched my stuff knows, I have not hesitated to criticize him and at times very sharply over one of the Trump prosecutions and other issues. So I'm not going to hold back. I never have, but know that about my relationship with Alvin. How did Alvin Bragg's office charge this case? How did he take the scenario you just laid out and turn this into an indictment?
If I can answer it objectively, and then we should get to subjectively. Objectively, what he did was wait. He has got his investigators to assess the evidence, and at some point, he takes out an arrest warrant to be able to charge Daniel Penny with a crime in this case, and then he brings the case to the grand jury. The grand jury returns an indictment of 2 counts. The first count is manslaughter in the second degree, which is a count that really talks about reckless conduct. The second count is criminally negligent homicide, a crime which many states have on their books and a crime which many states don't. When Alvin Bragg had first charged Mr. Penny, there was 1 count. Now, with the grand jury, there are 2 counts that Daniel Penny must face.
So the top count, the more serious count, which carried a 15-year sentence max, was reckless. I'm oversimplifying a little, but reckless was the top count, and then the lower count was negligent. And I was a prosecutor for federal and state, and to me, just the existence of negligence-based criminal laws doesn't vibe well with me. I understand there are plenty of state-level negligence-based crimes out there, but it puts prosecutors in a position of having to try to put someone in jail in this case for something that even the prosecutors here admitted in the beginning of their opening that at Daniel Penny's motives were noble at first. Even the prosecutors had to concede that. They said at some point it crossed the line. But to me, it's tough to try to, it takes away from some of the punch of your argument as a prosecutor. If you have to say, he didn't have intention to kill or hurt this person, he just was sloppy. That's not a convincing or compelling argument in my view.
Well, the difficulty with the case was always present because no one certainly believed that Daniel Penny intended to kill Jordan Neely. When I go back to your original question about the charges, we have to also look at the subjective point of view, which is what was going on about this case in New York City. Neely is deceased. We know that. Daniel Penny has not yet been charged and is going about his daily life. There was a great deal of protesting that began at that point that was directed at Alvin Bragg, the district attorney, that people wanted Penny to be charged with something involving this death. And they had a great deal of support from civil rights leaders, church leaders, and there was a lot of loud protesting. So Alvin Bragg, it seemed to me, this may be true or false, it was just my opinion. My opinion was that Alvin Bragg stepped first to do that first arrest warrant and that first charge because he felt this great deal of public pressure. On the other side, there are lots of people, and that I can't quantify a number, but it was no small number. There were lots of people who supported Penny, but they were not out at the courthouse protesting. They were at home saying, gosh, I wish if I were in a subway car that someone would come to my aid. But they didn't have a voice. So the case started to go forward. Daniel Penny cooperated with the government from the very beginning. He gave statements without the advice of counsel in order to just say what happened. And how this case became a crime, according to the prosecution, was not the fact of taking him down to the ground in a quote unquote chokehold. It was that he held the chokehold too long. So the question is, when does good conduct, heroic conduct, become reckless criminal conduct? Is it at minute 2? Is it at minute 4? When did it change? If you add into the picture your concerns, which I join, about the issue of criminal negligence, that even makes it more murky. When is his conduct blameworthy? There was conflicting testimony about the fact that when the police arrived, there was still a pulse or that he was still breathing. So if that testimony was true, how is Daniel Penny supposed to know that he is actually killing and therefore killed someone? On the side of the government, Elie, I do have to say, you did have people in the subway car who were saying, stop already, let him go, because he was not moving on the ground of the subway car.
One of the questions I might have asked rhetorically, if I was the defense lawyer in this case of the jury, is what is he exactly supposed to do? Let him up and go, oh, now we start this all over again? What do you think is going to happen if Daniel Penny takes the man down, subdues him, and then lets him up? You think Neely's going to go, sorry, everyone, my bad, I was out of line, I'm going to leave now? No, he's going to start right up with the whole same thing he was doing. So I think you've already answered the next question I was going to ask you, which is let's put ourselves in Alvin Bragg's office here. Let's say if you were the DA, and I'll answer as well, would you, and there's a separate question about how would you have found if you were on the jury, but before we get there, would you have charged this as the DA? I think your answer is pretty clearly as no, but I'll let you answer specifically.
Well, my answer, and it's purely personal, is no. At the same time, I can say I completely understand why Alvin Bragg charged this. And it was not, quote unquote, wrong to charge it. There was a reasonable basis to say that his conduct was reckless. But a reasonable basis is not proof beyond a reasonable doubt. To go forward with a charge, whether it was that Alvin Bragg as the DA felt pressured to do it or whether he felt righteous to do it. The issue, though, which has to be thought about by every district attorney, is the question of what is appropriate punishment should there be a conviction. And one of the things we think about in punishment is not only retribution, putting someone in jail, but it's also deterrence. That is, deterring others from committing this same alleged offense. Well, do we want to send a message to people in the city of New York or elsewhere that they should not help people who they see are under a possible imminent threat of death or serious bodily injury? Is that a message that the district attorney wants to send? And I think the answer to that is no.
Yeah, I think I'm in a very similar place to you, which is I would not have charged. I think I can say I've said this before the verdict came in. I would not have charged this. However, I agree with you. When you're looking at how do we critique Alvin Bragg here, in my view, there's 3 types of cases as a prosecutor, and God knows I've had to wrestle with all of them. There's the easy ones you have to charge, obviously. All the elements are met. You have the righteous cause. you're meeting the ends of retribution and deterrence and all that. That's most cases. Then you have a smaller group that no way, that one of the elements isn't there, or it's just an outrage and there's just this was in the middle. And the middle's the hard. The middle's what, not that it's a lot of money, but as to paraphrase Don Draper, the middle is what the money's for. And I do think that Alvin was within reason, within his rights to bring this case. I don't think it is a miscarriage of justice that he brought this case. I disagree with his decision, but I don't think he was out of those boundaries to bring it. And, a common comparison that gets made that I think is inapt is people say, well, it's like the Bernie Getz case, which happened, of course.
No.
Very different. Well, I'll tell you why I think it's obviously different is when Bernie Getz turns his gun and shoots those individuals, he knows he's going to either kill or maim them. And that's obviously his intent at that point. When you point a gun and shoot, that's Jordan Neely's intent, and intent is vital here, is I'm going to take him down, I'm going to hold him. And the argument was he held him too long, but that's very different than I'm going to point a gun and pull the trigger. What's your view on that?
100% different. What you have in Daniel Penny, and his one of the Marine trainers testified, is that there are also two kinds of chokeholds. We have been debating chokeholds in the criminal justice system for I dare say, decades. When is a chokehold proper? When is it improper? Some departments, police departments, outlaw them all together. Others look at chokeholds, depending on what kind of a chokehold it is, as simply being
blood choke and oxygen
exactly,
choke,
as simply being a way to get someone down to the ground who is not cooperating. One of the things that disturbed me about the ultimate charging decision,
right?
The medical examiner declared the cause of death as homicide. There is an argument that the cause of death was accident. I mean, those were her choices. She chose homicide before she got the toxicology report of the deceased Jordan Neely. That created an opening for the defense, not only in the courtroom, but also something they had tried to persuade the prosecutor about. This was a case where if you only look at the taking of Jordan Neely down by Daniel Penny, you're looking in a vacuum. Unfortunately, Mr. Neely needed a lot of help. He was someone who the system utterly overlooked. He was on a list of some of the most dangerous people in need of care for mental illness. He did not get the care that he should have gotten. He had drugs in his system, which make you act in ways you might not otherwise act. Even the mayor talks about the fact that it was the system, the city system, that failed Jordan Neely. We did not prosecute the city. We prosecuted in the name of the people of the city of New York, or the county of New York in Manhattan. We prosecuted Daniel Penny.
Yeah, I agree with you. I've heard it said as an argument, I think, against Penny, well, the system failed Jordan Neely. Of course it did. And the solution to that is not to lock up Daniel Penny. Those are just completely non sequitur, ships passing in the night, two different issues. I want to turn back to the way this case was charged, because the jury deliberation that went down over the last several days was fascinating and bizarre, and in some sense kind of illogical. Although obviously you and I both agree on the result. We both said we would not have charged it. So obviously we both would have been voting not guilty if we were in that jury box. The judge tells the jury, start with the more serious charge, recklessness. If you reach a verdict on there, I'll tell you what to do next. If you convict him on that, we're done. If you acquit him on that, then you go to the less charge. What happened was the jury got stuck. They deadlocked on the reckless charge. And they ultimately ended up acquitting on the negligence charge. Now, let me tell you why this blew my mind. It almost logically doesn't match up, because when the jury hung on the reckless charge, that means that at least one juror said, yes, he's guilty on a recklessness theory, and at least one juror said no. If at least one juror says he's reckless, he's guilty on reckless, how could none of them have said he's guilty on negligence? The only answer I can think of is they changed their minds. And it's okay. You're allowed. You're encouraged to do that as a juror. But tell me what you made of the whole way this whole deliberation went down. And I know there's criticism of the DA to be had here in the way they acted during the deliberation.
This jury sat for about a month. If I am correct, they heard over 30 witnesses, that they went into deliberations, and the deliberations took many days. On a Friday, which I believe was day 3 of deliberations, it could have been day 4, and you can correct me, whichever it may be, but they're many days. They're 3 or 4 days in. And on that Friday, they come back not just once, they come back twice to say that they cannot reach a verdict on the manslaughter charge. In each occasion, the judge has the right, and did, give them what we call the Allen charge or the dynamite charge. And what it really is to tell jurors that they should keep going at it, that they should not surrender their deepest feelings and thoughts, but that they should hold on to their opinions unless they can be persuaded by others to change those opinions. Ordinarily, I'm sure in your experience, certainly in my past experiences, both the prosecutor and the defense lawyer in both state and federal cases, the worst thing from a defense point of view is ever getting the dynamite charge, because almost always the jury says, okay, especially on Friday afternoon, we're just going to fold and we are going to convict. It is very rare on a dynamite charge, in my experience, that the jury suddenly says, oh, okay, let's acquit. Now, it could happen. When they were sent back the second time on Friday afternoon, or on Friday midday, the DA, having looked at the fact that the jury could not get to, they weren't allowed to consider criminally negligent homicide unless they acquitted on the top count of manslaughter, the DA said, well, we better do something or we're going to have an acquittal here. So I'll tell you what we're going to do. We're going to dismiss in the middle of jury deliberations the top count of manslaughter. I mean, I'm sure for you, certainly for me, this was unheard of. And the defense appropriately moved for a mistrial again and again. Because how can the government say, along with the judge who instructed the jury, well, I guess you can't acquit, so we're just going to get rid of this. So then you're left with only criminal negligence. So obviously, to both the DA's office and perhaps the judge, perhaps not, the jury was really, in essence, kind of being pushed, if not forced, to come back guilty on negligence. However, the judge did a very smart thing. He decided that the tempers had gone too high, that there was too much energy happening on Friday. So he decides to send the jury home. Going through the weekend, I'm like the defense lawyers. I'm out of my mind. I'm just furious. So if I'm the defense lawyer, I would come in, which they did on Monday, and say, I'm moving for a mistrial again, because they could only believe that if there were jurors who wanted to convict on the top count, they were not going to give up their opinion. Well, the defense got lucky. The jury went into the deliberation room to start again on the second count only, the criminally negligent homicide only. And in a very short period of time, they came back not guilty. So what happened? Over the weekend, somebody had a change of heart. We don't know at this point, was there one juror holding out for conviction, 2 jurors? It certainly wasn't 10 or 12 jurors holding out, 10 or 11 jurors holding out for conviction. or it could not have turned around that fast. Did someone in the jury room on Monday morning have a more persuasive argument for those reluctant jurors? And they came to a consensus. There have been a lot of psychological studies on jury deliberations. I participated in one as a lawyer doing a mock trial many, many years ago in Massachusetts. And these were mock juries who had been people at the courthouse who had not been chosen for a real jury. So they agreed to do the mock jury. And I don't remember if we had 50 or 100 juries that we tried a simple case to, and we could watch their deliberation. And the thing I learned from that, which was really important to my whole career, was what is called a secondary group, a group of strangers who are brought together for a common purpose, that is to do justice, to reach a verdict on a criminal case, that a secondary group over time morphs into a primary group where people have feelings about each other. They like you, they don't like you, they believe you, they trust you. We don't know what dynamic was created in this jury that allowed them to come back so quickly on Monday.
That is fascinating. I mean, the whole jury dynamic is so interesting to me. I want to pick up on a couple of things you said. So first of all, you talked about this Allen charge, the dynamite charge. You are right. Just so people understand what this is, when a jury sends a note saying, we're stuck, Judge, what do we do? They don't know what to do, right? Like, they're never instructed you can hang because judges don't want them to hang. Nobody, they're not supposed to hang. And so they get to a point where they all figure out, maybe when they're a secondary group, maybe when they've become a primary group, well, we're stuck. We need to tell the judge. And then typically what happens is the judge will give this charge. And it's something like this. While you jurors are not to give up your own personal beliefs, you are to keep an open mind. You have a duty, if humanly possible, to reach unanimity one way or the other and to reach a verdict. And if you, then there's the guilt trip part, the sort of, if you don't, then it's going to just set this whole process back to the start. We're going to have to bring in a whole new group of jurors and everyone's going to have to waste their time. And there's no reason to think that the next group of jurors is going to be any smarter than you. So do your damn job, right? It's pretty persuasive or coercive. I've seen it break through deadlocks. I've seen it not break through deadlocks. I always wish it would. It's funny, you're absolutely right. Most of the time when it does break a deadlock, the result is a conviction. I had one case where the jury said we're deadlocked. We wanted them to undeadlock. They came back and said, we really are deadlocked. They hung. It turned out it was 2-10 against us, which is rare, meaning 2 jurors wanted to convict, 10 wanted to acquit. They hung, and then we retried the guy and convicted him. So that's a rare circumstance, but it's a very powerful, persuasive, or perhaps borderline coercive tool that judges. It's perfectly legal. Most judges do it because we don't want juries hanging. Let me tell you what I would have told you, Rikki, if you were my client, the moment that jury came back with a verdict, right? I would have said to you, okay, Rikki, I think we did the best job we could here. I think we made a strong case, but I don't like the signal that we now have that there's a verdict. I don't like where this is heading. And let me explain to you why, client. We know that at least one juror wanted to convict you for being reckless. At least one. That's why they hung up. That was great. They hung on the high count. Awesome outcome for us. The problem is that one or more juror, mathematically, if they wanted to convict you on reckless, also wants to convict you on the lower negligence standard. And now they're unanimous one way or the other. We haven't heard the verdict yet, so we don't know what it is, but just brace yourself. This could be bad. Right now, I would also tell you, it's also possible that whoever was wanting to convict you on reckless has since been persuaded or seen the light and now has come over to our side. That could be the case too. And it turned out that was it. But the moment I heard verdict, if I was a defense lawyer, I would have said, oh, crap, they're going to convict him on manslaughter. Would you have felt the same?
I agree with you. The idea that you could have had at least one, we don't know how many, were there 1, 2, 3, 4, or 5,
right,
that were ultimately people who would suddenly really change their mind. I mean, we used to have the phrase where you would say to your client, bring your toothbrush.
Right. Don't bring a belt. Don't wear your shoelaces. This is right. When they take you into custody, they take that stuff away from you. Were you shocked? I mean, having obviously covered this case closely, when you heard the not guilty verdict, how did you feel about that?
I was not shocked when I heard the not guilty verdict, perhaps because I confess my own bias, that I just could not imagine riding the subway or walking on the streets of New York where if someone wanted to help me, that they wouldn't because they might go to prison. So I think my own bias stopped me from being shocked because it made no sense that they would not convict on the lesser if someone wanted to convict on the greater. And one day we may know why.
Yeah, it's true. They might talk. Jurors can talk. I'd actually be fascinated to get inside this jury's mind. I mean, I wonder if there was a gender split, a racial split, an age split. I mean, obviously they ultimately came together. And I think you're right. The subway is a really important factor here because if you live in a city with a subway, I guess I've lived in various cities, Boston, DC, that all have some sort of subway system. But the New York subway is sort of its own entity where it's gone through history. At times it was seen as the most dangerous place you could be. And, I wasn't supposed to go on the subway when I went into the city when I was in college in the 90s. I did. But, my mom would go, don't use the subway. It's a scary place. You're confined. You're in a metal tube with somebody, right? And so I think everybody has had that experience of being nervous on the subway. And everyone is probably many or most or all of the jurors have had the experience of sitting on a subway when someone starts to get menacing, when someone starts to threaten, when someone starts to approach people. What are you looking at? That kind of thing. And I think given that, it's really hard for me to see a scenario where all 12 said, let's send this guy. And to be again, this is not about, do you like, approve, affirm? Do you feel sympathy for Jordan Neely? Do you like what Daniel Penny did? This is about locking this man up, sending him to prison for years if you convict him, meaning Daniel Penny. And I just don't see any way that you would have got 12 jurors in New York to agree to do that.
As long as many of those jurors ride the subway.
These are all people who reside in Manhattan, New York County. So I would guess, not a lot of people in New York have cars in Manhattan, and even those who do depend on the subway. So I would guess that most or all ride the subway fairly regularly. Maybe if you're super wealthy, you can have a driver or something, but yeah.
No, they do, and they did. And I think the persuasive testimony in this case was the prosecution's own witnesses of the passengers in that subway car. You had a young woman who said, with all the things that she has ever seen, she has never been as terrified as that day. And that's the kind of stuff that no matter how good a prosecutor is, they can't get past that. And that's their own witness.
I do wonder to what extent there was a fairly recent, a month or so ago, attack in Midtown Manhattan, not the CEO shooting, a separate thing where essentially a person with serious mental health issues just randomly approached and stabbed 3 people. Obviously, jurors are not supposed to take anything else into account, but I wonder if they're thinking about that, about just the menace that exists. It can be scary. You're not gonna come out of it better when this type of situation happens. The best thing you're gonna do is get out of there intact.
Well, the difficulty, of course, of the stabber that you allude to is he is another person that the system failed. He was clearly severely mentally impaired, and he had been on the radar of the system, both the mental health system as well as the police. Same as, by the way, Jordan Neely. This was not someone who had never had an encounter with the police before.
He'd been arrested dozens of times, 30 sometimes. Yeah.
And what you find in these situations is that we should, as a society, be not only sympathetic and empathetic toward the men emotionally disturbed, but we should do more in terms of looking to our representatives on the city council and saying, there has got to be money and resources put into helping these people, because if we do not help these people, they will be arrested 10, 20, in some cases over 100 times, and nothing is being done to help them, and then they become more and more menacing. Not only on the street, as with the stabber, but let me tell you, inside a subway car. And I'm a very small woman. The subway car is the most threatening place. And if you have a long distance between two stops, which you had here, you really wonder if you're going to come out the same way you went in.
It's a great point. And I think often people recognize the problems that you're talking about with social services in New York and elsewhere. And then it becomes an easy solution, a convenient solution to say, well, we need a criminal conviction. We need to lock someone up. But the criminal courts and indictments and imprisonment are not the solution to any of this. Yes, there are cases where it is perfectly feasible, possible that someone goes too far, crosses the line. This was not that case. And I think you're right that in a way it almost pulls attention and pulls focus. The criminal element, the attempt to use the criminal courts as some sort of cure-all, pulls focus and maybe resources from efforts to address the real root of the problem, which is obviously would be in the best interest of all. Rikki Klieman, thank you for joining today. This was such a fascinating conversation. I think this case will continue to be discussed for a long time. I think it'll become part of the historical record in New York City. And I'm interested to see how else people view this. But I really appreciate your perspective. Thank you very much.
Well, I really enjoyed myself. You are a pleasure to work with, and I'm a big fan.